opinion on the application of not Builders Ltd for construction industrial training board.
Yes, Mr. Jaffe.
My lord, my lady, I appear for Not, formerly known as Hudson. Mr. Lee, my junior, has asked me to send his apologies to the court, and Mr. Knight appears for the construction industry training board.
Yes.
We're very grateful to the court for its helpful indication on timing, and subject to the views of the court.
Well, was it helpful? We're listed for two days, and so we weren't being entirely prescriptive. If it is possible to contain the arguments in that sort of scope, then so be it. But obviously, we've got tomorrow if we need it.
Well, we intend, subject to the court, to have a good go, and we assume from the court's indication that it's had the opportunity to read some of the materials.
We have.
And so, therefore, we'll do our best. I plan to, if I may, complete my submissions this morning with Mr. Knight, then responding this afternoon.
Yes.
And again, subject to the court, we've agreed that I'll go first.
Yes. And both of you are appealing.
Of course.
Have you reached an understanding that it's sensible for you to cover all the ground you need to cover, subject to a right of reply, as you have done in the skeletons? Or are we going to do you first, then in four chunks?
I'm hoping that it won't take 4 chunks.
No.
What I intend to do...
The arguments are 2 sides of the
Yes.
various coins, aren't they?
It's likely I'll need to reply, but I can wrap that up, and it may be that Mr. Knight needs to have a few words at the end in relation to cross appeal only.
Yes.
I hope that's going to be very brief. I intend to open all of the relevant facts and summarise our position on all of the arguments on both sides.
But we have not only had the opportunity of reading a lot of the documentation, we've taken it. We're very grateful to counsel for the skeletons on either side, which do set matters out. The only other timing parameter, unfortunately, is that I've got to take part in what's called a town hall meeting on the web at 4:30. No idea what it is, but it's a lot of people, and I've got to be back in my room for 4:30. So I think we need to finish at 4:15 if we can, please.
Understood. Well, my lords, my lady, this appeal, as the court knows, concerns the board's closely linked grant and levy scheme. The board collects levy under a statutory scheme and applies the levy to pay grants. And the grant is in practice paid by setting it off against levy obligations. The case is slightly messy, and the appeal is slightly messy because it concerns 3 different grant years. There are different issues in respect of each grant year, and the grant years and the levy years and the eligibility periods, I'm afraid, don't even begin to match up with any particular sense. So what I propose to do is just to briefly summarise the issues that the parties asked the court to decide before turning directly to those issues. Ground 1 of Nott's appeal concerns the waiting period before a company becomes eligible for grant. The grant terms and conditions say that there is no right to a grant immediately for a newly registered company, with some very limited exceptions. At the time, this is no longer the board's policy. The board has since changed its policy. It was necessary to wait for a period before being eligible for most grants. And Nott's concern is that that rule operates particularly unfairly on it because it's not a new entrant to the market. It's been around for many years. And Nott also says it was unlawful for the board to fail to register it many years previously. And that was a submission which the judge rejected. Now, failure to register, if the board had done it, would not have led to anything other than the board reaching a nil assessment in relation to levy, but the waiting period would have been served. And Nott's case is it was wrong to rely, or wrong for the board to seek to rely on its own failure to register Nott in a timely way. What the judge decided was that in respect to the first grant year, the waiting period, the board unlawfully failed to consider whether to depart from its own policy of requiring a waiting period, and the judge remitted that issue to the board for reconsideration. The board appeals from that limited finding made by the judge below, whereas we say the judge should have gone further. The judge could and should, we say, have determined that issue herself because there was only one lawful answer to it, or at the very least, the judge should have given declaratory relief to assist the board in its reconsideration on the question of the lawfulness of the board's past conduct. and the board obviously disagrees with that. So that's ground 1A of Knott's appeal and the board's cross appeal.
Thank you.
Ground 1B of Knott's appeal is another route to the same result in respect to the first year. And that is that Knott says it has a legitimate expectation of being eligible for grant in that year as a result of what it says are clear and unambiguous statements made to the administrative court by the board's then counsel in the course of seeking to persuade the court that it was reasonable to impose a levy liability on Knott. And the judge rejected that submission. And our case is that she did so as a result of an unfortunate misunderstanding of the evidence that was before her. And I'll develop that in a moment.
Thank you.
That's ground 1B. Now, if Knott is successful in obtaining at least some grant in that first year, that is likely to have a significant value to the parties, and we've attempted some calculations in our skeleton at paragraph 28, which I won't go through now. So those are the issues on ground 1 and the board's cross appeal. Ground 2 of Knott's appeal is about what can be claimed for across all the years. The board's basic case and its decision is that grant claims can only be for training and inductions which have been delivered by Knott itself. And what the board says is that it imposes what it calls, and what the parties have called, a tripartite requirement. That Knott has to identify the need for training, first of all, secondly, arrange the training, and thirdly, pay for it. And the board's view, which the judge agreed with, is that Knott does not do this in respect of training that Knott's clients provide, which is the bulk, but not all of its grant claim. Now, the way those arguments split down is that ground 2A is that in the first two grant years, 2015, 2016, 2016, 2017, that tripartite requirement and various other technical rules relating to it were removed from the grant terms and conditions. The evidence, and indeed the judge's finding of fact, was that the removal of those provisions was a deliberate decision. Knott's case is that as a matter of legitimate expectation and fairness in the application of a policy, that it is entitled to have applied to it the grant terms and conditions without that requirement. The judge concluded that that requirement was lawfully reintroduced as a result of a letter sent in October 2017. The other limb of ground 2, 2B, arises if Knott is wrong about 2A. And it also arises in respect of the third year. That's because the tripartite requirement was put back in policy in the third year. And we also say the judge was wrong to find that the requirement was not met. And then last but not least, there is a respondent's notice served by the board, and the board says that any relief ought to be refused for the last 2 years. And why is that? Well, the board says it waived a rule which normally prevents late grant claims and retrospective grant claims, but it never would have done that had it known about a corporate reorganisation which took place in 2018. Our response to that is that that's simply false as a matter of fact. The documents before the court show that the board and its solicitors were well aware of the reorganisation. Indeed, the directors were threatened with legal action as a result of the reorganisation.
Did the judge make any findings on those points there?
Is that in your skeleton?
No, because that arose by reference to the respondent's notice, and I'm afraid we didn't deal with it in detail in our skeleton.
Well, you don't deal with it at all, I think.
I apologise for that oversight. It also been covered.
But we're hearing your position on that for the first time. Is that the first time that the board and Mr. Knight have got to learn of your position on that?
No, the point was taken below that relief should be refused.
No, but in the context of the appeal,
Yes,
the respondent's notice is filed, and this is, in outline, your response to it.
Yes. Well, the way it was put in my learned friend Skeleton, I make no criticism of this, is the argument has now been put much higher than it's ever been put before. The argument is put as a lack of candour, including in the context of this underlying claim for judicial review by not, which is obviously a serious matter.
Yes,
And
but if that's right, it is, and all the more reason why one would have anticipated a written response. And the respondent's notice was February, wasn't it?
well, I will check where we dealt with it, but I think we did say that it ought to be refused, and if it hasn't, I apologise.
Well, we won't take time now, but it's clearly not a satisfactory way of presenting arguments which need to be put forward, understood, responded to if necessary, and laid out before the court prior to the beginning of the hearing.
Yes. Well, it is also fair to say that the temperature of this allegation, as put by the board, has increased significantly. A request that relief be refused in the last 2 years was put to the judge. It was put in a very moderate way, and the judge rejected it. The way the case has been advanced before this court is somewhat different, and so I'm afraid our responses have to be somewhat different. What my lord puts to me is that our written submissions have not focused on that as perhaps they should, and I apologise for that.
Well, let's move on.
What I propose to do in dealing with those points that I've outlined is to make 6 submissions. Firstly, and I'll do this very briefly, is to look at the statutory scheme for the levy, in particular to identify and resolve the point as to whether there was a legal duty to assess for levy and to register for that purpose. Secondly, I'll look, if I may, at some of the grant scheme terms and conditions to identify the differences between different scheme years. Thirdly, a few, but only a few, of the relevant documents which are before the court, which are relevant to the grounds. And then I'll take the grounds in turn. So as my 4th topic, ground 1A, the temporal restriction, and the legitimate expectation argument. As my 5th topic, the tripartite requirement, and then finally the response to the cross appeal and the respondent's notice issue.
Thank you.
So I'll start, if I may, with the levy scheme. If I could ask the court, first of all, to look at the Industrial Training Act, which is in the authorities bundle 1 at tab 2. As the court will have seen from the skeletons, the critical definition in the Act is in section 1, subsection 2, on page 7, and it's the definition of an employee. And it has a special extended definition, and it includes a person engaged under a contract for services, as well as of service. So it includes a self-employed person, as well as a person who is what I'll call, if I may, a traditional employee under a contract of service. That definition is then carried through, of course, into the levy orders. Then on page 14 of the authorities bundle, there's section 5.4, which deals with grants. And that gives the power to an industrial training board to D, make payments to persons in connection with arrangements under which they or employees of theirs make use of courses or other facilities provided or approved by the board. So that's the power to make grants for training. And the reference there, of course, to employees is used in the extended sense in section 1, subsection 2. Then in section 6 over the page, there are information gathering powers, and that is the power used by the board to insist on the production of levy returns and other information of a kind approved by the Secretary of State. And then on page 20, section 11 contains the levy power. And under section 11, subsection 1, the Industrial Training Board submits to the Secretary of State proposals for the raising and collection of a levy, and the levy is then hypothecated. It's not general taxation, but it's raising money towards meeting the board's expenses, which of course include its power to make grants.
Yeah.
Then subsection 2, capital A, provides for levy periods, which are the periods by which liability to the levy is established. So those are the days on which, if you're an employer in the construction industry, that you have levy imposed on you. And that may be as short as sometimes 2 or 3 days in a prescribed year. Then the base periods are in 2E.
Just to help me understand, why would that be a good thing to have a levy period that was just 2 or 3 days? Is that?
It's not a good thing. The reason is that...
Well, why would they do it?
It's because the negotiations for a levy order with the Secretary of State involving industry consultation have historically had a tendency to run right up to the line.
Right. So,
And so the levy periods have often been extremely truncated for the first levy period in a 3-year order.
yes.
Because the
They're
negotiations...
just picking up the last bit of the period that they might have had if they didn't finish sooner. Yeah.
So often you're just testing whether or not someone is an employer in the construction industry for a period of days sometimes.
Yeah.
In relation to later periods in a 3-year order, it's normally the first quarter of the year, which makes a little more sense. That's how it tends to work.
Thank you.
I should add that if it helps, in the supplementary bundle we have done a diagram of the various levy periods and the base periods with the relevant dates in this case superimposed on. Because my eyesight is a bit iffy, we've got some A3 versions. If any of them, if the court would like a larger version, I'd be happy to hand them up.
So sorry, which tab?
It's in the supplemental bundle at tab 3. My apologies, tab 2. And I don't know whether it's legible in the court's copy, but I do have some larger ones to hand up.
I put the same information into a table.
Okay.
Yeah.
I was a bit distracted by the colours.
I can read it.
I'm great.
Yeah.
So then the quantum of the levy is assessed by reference to the base periods, which are invariably a tax year, and a tax year sometime before the levy period. And that then brings me on, if I may, to the levy order, and the relevant one for our purposes is the 2015 order, and that's in the authorities bundle at tab 3, page 46. As we can see from the top of page 46, this order was made on the 10th of March 2015, and under Article 1 of the order, on page 47, it comes into force on the following day, so it came into force on the 12th of March. It was made on the 10th of March and came into force on the 12th. The only relevant definition for our purposes and the interpretation clause is Article 2 on page 48, is Article 2H, which is the definition of a labour-only agreement, which is an agreement or arrangement other than a contract of service, apprenticeship, or a contract which requires substantial use of plant, specialist equipment, or both, between an employer and any other person, the purpose of which is wholly or mainly the provision of services, not including professional services. So, in very broad terms, that is what the industry calls a labour-only agreement, because the primary service being provided is the employee, in the broad sense, is labour, with only limited use of specialist equipment. Article 3, page 50, imposes the levy, and under Article 3.1, it's imposed on employers in the construction industry. And that, of course, has the same meaning as in the primary legislation. It includes self-employed people as well as the traditional employee. And therefore, an employer in the construction industry is interpreted in the same way. A person engaging a self-employed person is included. The first levy period is then defined in 3.1a, which is from the date on which the order comes into force, which is the 11th of March, and ending with the 31st of March, so a 20-day period. And then the second and third levy periods are the first 3 months of 2016 and the first 3 months of 2017. So those are the dates on which liability to the levy is tested. And they're recorded, for those of us that are using the diagram, just above the black timeline as the area which is shaded and surrounded by open brackets, just above the timeline.
Yes.
Article 5, which is on page 52, contains what we say is the duty to assess levy, which is imposed on the board. So Article 5.1 provides that the board must, mandatory duty we say, assess the amount of levy to be paid in respect of each construction establishment of an employer. Now, in order to fulfil that duty, we say that logically, the first thing the board must do is to identify all construction establishments. And there's a definition of a construction establishment in Article 5.2 as well. And then, having identified the construction establishments, the board must assess the amount of levy to be paid by each of them under 5.1. And as we'll see, the assessment may be a nil assessment, but nonetheless we say it still has to be carried out. And the implication of that, as I've already explained, is that if that duty is not carried out, it has important implications for grant, because there's a waiting period following first registration. Then Article 7 on page 54 contains the two different levy formulas. Without going through it, I'm just going to summarise it this way, which is that in the first and second levy period, a company such as Not was entitled to deduct sums which it received from its clients in respect of labour-only services. And given that it was a company which made a profit, in other words, it received more from its clients and it paid out to its operatives, the levy which was imposed on it would be nil, de minimis certainly. That formula changed in respect of the third levy period, and the formula was changed to A plus B without a deduction, C. The percentages changed, and the basis, B, also changed, but the upshot was that the levy assessment of a company such as Not would no longer be nil, it would be substantial. And the effect of this change in policy, reflected in the levy order, was that levy was usually being paid by a firm which is further up in the contracting chain. The final provisions which are relevant for our purposes are in Article 10 on page 58. And it's the final part of what we say are the duties imposed by Articles 3 and 5 as well, is that the board is under a duty, it must serve an assessment notice on every employer assessed at the levy. And then there are detailed provisions, including under 10.3c, for the levy assessment to be based either on information submitted by the employer or, in the absence of that, a reasonable estimate by the board. So, just as is the case in respect of direct taxation and also the case in respect of VAT, in the absence of sufficient cooperation, the board is entitled to and does serve an assessment based on an estimate. So that's my first set of submissions relating to the levy scheme.
So may I just ask a question, please, Mr. Jaffe? Can an employer in the construction industry spontaneously ask to be registered?
I suspect they probably can. Whether they would be registered by the board would depend on the board's view rather than the company's view as to whether the company is an employer in the construction industry.
Right. And if they asked to be registered, would there be a waiting period after they were registered before they were eligible for grants?
Under the board's rules that applied in the relevant years, I assume the answer to that would be yes. What my lady is putting to me relates to some of the findings made by the judge, where the judge in essence said, well, you know, you were opposing registration, you disagreed with registration, and you could have come along and asked to be registered before. And the answer to that, and I'll develop it when I get to the factual section of my submissions in a moment, is that Hudson, as it was then called, not as it's now called, did engage in detailed terms with the board before the coming into force of the 2015 levy order, and it asked what the effect of the order would be and what it needed to do, including in terms of registration. And we'll see the answer that they got, which we respectfully say the judge didn't properly take into account. So I'm very alive to the point that my lady is putting to me, and that's the point which I will need to deal with.
Okay, that's very helpful. Thank you.
The second part of my submissions relates to the grant scheme. And with apologies in advance, I'm going to briefly show you 5 grant schemes. The 3 years in issue in this appeal, which I'll do quickly, but also the preceding year and the following year to see the changes. And I'll do it in chronological order if I may. So can I start in the supplemental bundle, the first supplemental bundle, tab 14, page 140. These are the 2014-2015 grant scheme terms and conditions. So this is the year before the first issue, which is an issue in this appeal. And the relevant grant year, at least at this time, broadly corresponded with the academic year. It ran from the 1st of August 2014 to the end of July 2015. The important headings for our purposes are the second heading on page 140, who can apply. Most employers with a main activity of construction who are registered with CITB at the time of the application, including those who don't pay a levy due to the small business levy exemption. So registration is a requirement. And then we have a statement of the temporal restriction. Any employer who registers with us and is converted in scope levyable between the 1st of April 14 and the 31st of March 15 will be eligible to receive all grants from the 1st of August 2015. So after the period has ended. And then that is repeated and amplified in the next section. Who can't apply? First bullet point, newly registered employers, those registered between the 1st of April 14 and the 31st of March 15, can't apply for grant until the 1st of August 2015. This is because their first year of levy liability will be based on their 2015 levy return and will not be raised until spring 2016. So those are the provisions for the waiting period. And then on page 141, we have what we've called the tripartite criteria. And on page 141, in the top half of the page, there are some bullet points. And the third bullet point is you must identify the need for training, organise the training and accept the cost of training. And then there are other procedural requirements that follow that. You must obtain signed documentation from the actual employer, if the labour-only subcontractor, that no application for grants in respect of this training has been submitted by them. And you must keep documentary evidence to illustrate these criteria have been met. So there's the basic rule in the third bullet point, and then supplementary procedural rules. Then finally at page 144, towards the bottom of the page, there's a heading, how and when is grant paid? And the last sentence of that section, the board shall be entitled to set off any monies owed to you under the grant scheme against any monies owed to you by us. And so there is a set-off arrangement in respect of levy obligations.
Just while we've got that page open, my eye fell upon the first subparagraph under that heading, how and when is the grant paid. If your application is successful, we aim to pay the grants, together with any supplementary payment to which you're entitled by bank transfer, cheque, when the training is completed, and in any event within 28 days of your grant application. So it isn't a prerequisite that you have to complete the training. You get the grant anyway? Is that how that reads? Or is it that you have to complete the training?
Well, I imagine that the board would say, and Mr. Knight may be able to assist, is that it isn't going to be paid in any event until the training is completed. But if the application is made after the completion of the training, then
right, I'm with you.
Pay
That's the long stop. Yep.
So in any event, we're not paying you until you've done it.
Yes.
But if you have done it, we'll try and pay you within 28 days.
Right.
I think that's what that means.
Yeah.
So that's the preceding year. In addition to showing what the context is, that's also relevant to the legitimate expectation argument, because those are the terms that were cited to the administrative court and which the judge said were inapposite and irrelevant to the temporal issue. And that is what led to what we say is the confusion in the judge's judgment between 2 years, but I'll come back to that. Tab 15, page 147, is the first relevant year for our purposes. It still contains the temporal restriction. We can see that from the second paragraph of who can claim at the top of the page. Employers newly registered between the 1st of April 2015 and the 31st of March 2016 will be eligible to claim new entrant and apprenticeship grants retrospectively and all other grants from the 1st of August 2016. and then the same explanation is given. And we know that applies on the face of it to Not, because Not was registered to levy on the 16th of February 2016. And that's marked in the top left of the diagram in green. The next part of the relevant part of these terms and conditions is the third heading. What criteria must be met before a grant claim is processed and paid? And there are 2 bullet points. A 2015 levy return, it shows the link between levy and grant, must be correctly completed and received prior to the 31st of December 2015 for a grant application relating to this grant scheme year. And then the levy must either be fully paid or subject to direct debit arrangement. Now, both of those requirements were waived by the board because by that point, because it was a retrospective application, Not had not submitted a 2015 levy return prior to the 31st of December 2015, and the levy was not fully paid or subject to a direct debit arrangement. So some of the requirements in this scheme were waived by the board. And then finally, what's significant about this policy is what's not here. This is a shorter grant policy than the previous year, and all of the requirements we just went through in the previous year's policy about the need to identify training, the need for training, organise it, accept the cost of it, get signed documentation showing that nobody else received grants, and so on, have all been removed.
Is that right? I mean, the word training appears 5 times, I think, under what can I claim for, who can I claim for, what can't I apply for, what supporting documentation must I keep, provide, evidence of training, duration, attendance and achievement. Training is shot through it, isn't it?
Oh, absolutely, my lord. Training, and the concept of training is shot through it.
Yeah, and showing the duration of training, that sort of stuff.
Yes, absolutely.
And quite detailed stuff about the training that doesn't count.
Yes, that's right.
So training is essential, isn't it?
Absolutely.
The grant?
I entirely agree.
Yeah.
But what is missing is a separate and additional requirement that Not identify itself the need for training, organise the training itself, and accept the cost of it. There was also a requirement that signed documentation be obtained that nobody else had received grant in relation to the same training, and that has also, we understand, been removed.
But if you haven't accepted the cost of the training, why on earth did you receive a grant in relation to it? I mean, never mind what the terms and conditions say, how could it be rational to say, oh, well, you get a grant even though you haven't had to pay anything out in relation to the training for which you're receiving a grant?
Well, the answer to that comes from the particular nature of Not's business model and the change in this year which occurred, which is the third levy period under the 2015 order. Because what happened in practice when the third levy period started and when this levy year occurred is that nothing changed in reality. Previously, Not's clients had been carrying out training. Previously, Not's clients had been claiming from the board for that training. And as I'll seek to develop in a moment, as a result of the change in these arrangements, many of its clients were no longer able to claim for the training which they had carried out. Despite the fact that costs were being incurred for that training, including of paying staff whilst the training took place when they could otherwise have been carrying out their work.
So you're going to explain how that came about?
Yes, I will.
Okay.
But I don't understand that to be substantially disputed. The upshot is that the reality of this change and the imposition of the waiting period is that during this year, there will be clients of Not who are unable to claim, and Not is unable to claim. Now, if that's the legal effect of the scheme, then so be it. But we say that's wrong, and one of the reasons that's wrong is because the costs in practice operate in a somewhat back-to-back way, which is that Not charges its clients for the hourly rate of the operative. It then pays that sum to the operative after deduction of tax under the construction industry scheme. For some of those hours, the operative will have been carrying out training. And the only training which Not has substantially claimed for in relation to client training is health and safety training in particular, because it says it imposed obligations under its contractual scheme to do that. And we say that there was, in answer to my lady's question, an obligation to do such training, and that such training was in fact carried out. And I'll come to that in a little more detail when we get to ground two, and I'll try and make good those points. So, what happened in relation to these terms and conditions in 2015 and 2016 is that the provisions relating to the tripartite requirement were, on any view, removed. And the judge recorded in her judgment that the publication of these terms and conditions was accompanied by a leaflet. With apologies, I'm afraid that leaflet didn't make it into the supplemental bundle, but my learned friend, Mr. Knight, has a copy, and with the court's permission, could I hand up that leaflet? It's only 2 pages.
Yes.
It was before the court below, and it is referred to in Mrs Justice Ellenbogen's judgment.
Yes. No objection, Mr. Knight.
No objection, my lord.
Yes, of course.
Thank you. Thank you.
So because it's a leaflet, the printing is, the pages are slightly in the wrong order, but starting on the right-hand side of the first page, there's a cover page, highlights of the 2015-2016 grant scheme. And then the next page, which is on the left-hand side, there's a heading, You're Shaping How We Use Employer Funding, and there's an icon that says Investment Funding Review. And what the board says is they're overhauling how we use employer funding in response to your feedback. We've been listening. You've told us you'd like our funding to be simplified, easier to apply for with clear criteria and decision making. And there's then a response to what was said in consultation workshops. Then there are a series of colourful boxes which essentially repeat the same points. And the second box, under the heading we will support easier to access funding, simpler rules, more support on what you need to know to access funding, more frequent opportunities to apply, and more flexibility on how long programmes can run. So there was a contemporaneous explanation provided to the industry as to why the rules had changed in 2015 and 2016, and the aim was one of simplification. Easier to apply for funding with clearer criteria and decision making. And as we say, the judge correctly found, far from these changes being unauthorised or unapproved, they do appear to have been implemented deliberately and then explained to the industry in a leaflet. So that's 2015-2016. 2016-2017 is the second year that we're concerned with, and that's at tab 17 of the supplemental bundle. This policy is materially identical to the previous year, except that all of the dates, of course, are pushed forward by a year.
So that's year 2
That's
for
year
our
2.
purposes. Yeah.
And then year 3 for our purposes is tab 19, page 175. And there's only one relevant difference for our purposes, and that's on page 176. Under the heading at the top of the page, who can I claim for? Bullet point 5, you must identify the need for training, organise the training, and accept the cost of the training. So the tripartite requirement is back in the third year. And then finally, and this is not one of the 3 years that we're concerned with, but the following year, 2019-2020, is at tab 21 of the supplemental bundle.
Yes.
And this policy was, just to place it in the chronology, published and also came into effect for a grant year prior to the decision being made that's under challenge in this case.
At the top of page 189, the date's obviously wrong, isn't it?
Yes, it is. There's a typo,
Yeah.
and the correct date should be the 1st of April 2018
Yeah.
to the 31st of March 2019. There is a typo.
you.
That's right. But this policy was for a period starting on the 1st of April 2018, sorry, and then finishing in March 2019. So it finished about a year before the decision was made in this case. And what the board did in this policy, halfway down the page, is set out where it says if you're registered for the first time between the 1st of April 2018 and the 31st of March 2019, first bullet point, as before, you can backdate apprenticeship claims, but then this, you can also claim for all other grants from the registration date until we issue the 2019 levy return, when normal rules apply.
Yeah.
So the approach changed, and the board's policy changed before it took the decision in this case to abolish the waiting period. And it abolished the waiting period before it took the decision in this case. But nonetheless, it's the board's position that it did not need to even consider whether or not to dispense with the waiting period in the case of not. And that's one of the factors that we rely upon, that the board's general policy had already changed. So those are the grant terms and conditions. Subject to any questions from the court about those, and I realise I've stacked up a couple from my Lady Justice Laing, which I'll come to. I'll turn, if I may, to the facts.
Yes, thank you.
I'm not going to describe Knott's business model because it's apparent from the skeletons, but what I will do, if I may, is just identify some of the key documents over the years which have led to this appeal. The first relevant fact goes back as far as 2008, that is when the board first became aware of Knott, then called Hudson's business. That is in the supplemental bundle at tab 24, page 209. This is an email from Mr. Byrne, who is the board's witness in these proceedings in 2008, asking his colleagues in the levy registration team to register Hudson. And registration is the administrative process of putting a firm on a register which triggers a statutory levy assessment. The purpose of registration is to include a firm on the list of those companies that will be assessed every year.
I think you make the point that the registration scheme is not mentioned at all in the statutory instruments.
No,
it's just an administrative,
purely administrative scheme.
Back office arrangement.
But the purpose of registration is to identify those firms that ought to be assessed under the statutory scheme, under Articles 3 and 5 and 10. So in the next tab, tab 25, there's a letter, no doubt in standard form, from the board to Hudson, informing it, and this is 3 paragraphs from the bottom of page 210, we've reason to believe you're an employer within the construction industry and have placed you on our register. Then they say they don't backdate levy assessments, and then they ask for a questionnaire to be completed. There's then a series of responses from Not, then Hudson, at tabs 26 and 27, saying we're not registrable because we're not within the jurisdiction of the board and we're not an employer in the construction industry. And there are 3 letters to that effect at tabs 26, 27 and 28. And then at tab 29, by January 2009, the board accept that position. So at page 215, tab 29, the second paragraph says, we accept that Hudson is not an employer in the construction industry, since its business is providing services to the construction industry rather than working in the industry itself. And then letters in similar terms were sent at tab 30 to various of Hudson Knott's clients. And the relevance of the letters at tab 30 to the clients is that whilst it was the board's view that Hudson Knott was not subject to the levy, it was the view of the board that clients were subject to the levy. And the clients were offered the opportunity of an appeal to the Employment Tribunal against that conclusion. And that is what led, ultimately, to the decision of this court in the Beacon Roofing case in 2011. With apologies for jumping around and asking the court to look at the authorities, that's in the authorities bundle at tab 13. Mine are split into 2 and it's in the second volume of the authorities. They're giving me a bad record.
Yes, that's per tab on the GMC.
Sorry, I apologise, it's the first bundle at tab 9.
You weren't even close, were you?
No, not even the right bundle.
Yeah.
And the Court of Appeal held that the board was right and that Beacon Roofing and other of Hudson's clients was indeed liable to pay levy. But the Court of Appeal also made comments which pretty clearly suggested that Hudson was also properly within the scope of the levy. And the relevant part of the court's judgment is the judgment of Lord Justice Longmore at paragraph 22, page 214 of the authorities bundle.
Presumably, not Hudson weren't parties to the litigation.
No, they weren't parties to litigation, but it's fair to say they were very well aware of it.
Yes. Sorry, which paragraph?
Paragraph 22.
Yeah. Thank you. Would you like us to read that?
Could I invite the court to read it?
Right.
So the Court of Appeal emphasised that it was the purpose of the contractual arrangement that was all important, and in particular between letters G and H in paragraph 22, there's no distinction drawn by the Court of Appeal between the analysis it applies to Hudson Knott's role and the analysis it applies to Beacon Roofing. Now, at the time, because of the formula, A plus B minus C, Hudson Knott's liability would inevitably be nil. And indeed, the board did not do anything about the position of Hudson and also other firms in a similar position. But the absence of registration ultimately made a difference once the rules had been changed, as we're about to see. And this brings me to the answer to my lady's question of, well, when the 2015 order was in the offing, surely Hudson Knott should have been thinking about what they needed to do to protect their position and also to reflect it, including perhaps seeking registration if they thought that was the right step and in their commercial interest. Well, when the 2015 order was in draft, that is what Knott Hudson in fact did. That's the correspondence at tab 31 of the supplemental bundle. This is it's an email, so it's in reverse order. So I can pick it up at page 228, the second page.
Just the first sentence on 227. Is this one for the simplification team? It's refreshing to think that the board may have such a team.
Well, the aim of the new formula was intended to be simplification.
Yes, well, that must, I'm joking apart. That obviously is an aim, and it's a laudable one.
May not have in practice been entirely achieved, but that was the aim. And that was the name of the team that was introducing these changes. So page 228, there is an email sent via the board's website on the 25th of September 2014. And this is after a draft version of the 2015 order had been published. And Mr. Anfield, who's one of the directors of Hudson Knott, sent an inquiry. And he said, I've got some questions about changes to the levy scheme. How and when does the CITB intend to deal with companies that make net payments under the construction industry scheme? That's obviously Hudson Knott, but who are not currently registered with the board. Does the board intend to visit companies not registered in 2017, then attempt to impose a levy on net CIS payments from 2015-2016? If so, they'll have made no accrual and won't be able to pay. Then there are a series of more general concerns about the policy that's being proposed. And turning back to page 227, There's an acknowledgement of receipt at the bottom of the page.
I see that it's the reference to phoenixing.
Yes.
In the construction industry, I've heard it called much worse than that, which is the scourge of the construction industry.
Yes.
It's not phoenixing, so the construction industry has such a terrible reputation, I'm afraid.
And indeed, that's one of the purposes, for example, of compliance with the construction industry scheme for taxation purposes. And one of the things which Hudson not does is it guarantees that the tax is in fact going to be paid promptly to the revenue in respect of the work of individual contractors. As my Lord Justice Coulson puts to me, that has historically been a scourge of the industry.
Yeah.
And one of the things which is paid for, the £15 a week charge, is to guarantee that that payroll requirement and the special scheme of taxation for construction industry personnel, which is much stricter than pay as you earn, is definitely complied with, and Hudson take on the responsibility for that, including the liability to pay if there's any error or failure to account.
So this query is at a time when the 2015 order is in draft,
exactly,
but not yet come into force.
Yes. What is being said is, first of all, how are we going to be how are firms like us going to be registered? What's going to happen? How are we going to be introduced to the board? And then secondly, there are a series of complaints, which obviously I don't rely on in these proceedings, that Mr Anfield thinks that this policy is a bad idea because it's actually going to enable phoenixing, and it will enable levy obligations not to be paid more easily by firms at various levels of the chain in construction contracts. Now that's his view, and it wasn't accepted, and it's not relevant to these proceedings, but you may have had a point. Anyway, there was no response in substantive terms to that inquiry. At page 227, there was an acknowledgement of receipt, and it was sent on to the levy simplification team, but there was no response. So, undeterred, at tab 32, Mr Anfield had another go, and he wrote directly to a named senior official at the board. And then he made, in that letter, some of the points that were just made to me by my Lord Justice Coulson, in, for example, the 5th paragraph about the labour supply market being riddled with VAT and CIS fraud, and phoenixing every 12 months to avoid potential liabilities and the difficulties of collecting from these companies. And then he sets out a list of questions. The second question is, do you intend to collect a levy from all companies making net CIS payments, or just those that were registered during the relevant periods? Do you intend to register non-construction companies if they make net payments under the CIS? Then question 5, are you going to make training grants available to all CITB registered levy paying companies? He's obviously asking about his own position here. And then question 6, how and when do you intend to introduce yourself to those companies not registered with the board but making net payments under the construction industry scheme? It's obviously them. And then he makes his point clear, as the managing director of a company that makes tens of thousands of net payments under CIS every year, I'd like a response. And he gets a response. That's tab 33. First of all, the board says that it thinks its change in approach is a good one. It's water under the bridge. And then there's an answer to the questions at page 231. The answer to question 2 is that no, levy will only be assessed against in-scope employers registered with the board. The answer to question 5 is training grants are already available to all CITB registered employers. And 6, an introduction, that's an introduction to the board, in other words, a form of first registration, is not necessary if there's no impact on employers not registered with the board. And of course, at the time, Hudson was not registered. No, it was not.
Yes.
So, quite a lot of reassurance was given, Nonetheless, Hudson Knott remained very concerned about whether the board was in effect going to pull a fast one and register them anyway, and then impose liability on them. So it sent a pre-action letter, and the pre-action letter is at tab 34. And the relevant part of it, expressing the concerns, is page 235, paragraph 4.8.2. And 4.8.2, it says, because the claimant, that's not Hudson, is net paid and pays net, the clients will be required to pay the CITB 1.25% of the total labour costs. The claimant, not Hudson, will have to pay 1.25% paid to its operatives. That's a lot of money, because the claimant has a turnover of £1 billion. And 4.8.3 is the practical effect of that. And the practical effect of that is that most of Hudson Knott's competitors have managed to, or seek to, persuade the revenue to allow gross payments. In other words, they don't deduct tax. And if they don't deduct tax, then they're not liable to pay levy under the new formula. And that's the risk of phoenixing. This new policy encourages individual, supposedly self-employed contractors to be paid gross rather than net, because gross payments are not subject to the 1.25%, only net payments. And Hudson's business model has always been one of only permitting or only working with operatives who will be paid net, that everybody is going to have deductions for tax paid directly to the revenue. It's not the case across the industry. Now, the response of the government legal department, not the board, was initially that you've got no standing because you're not registered. And that led to more correspondence at tab 35. And it's politely explained by not Hudson's solicitors at the time, paragraph 7 on page 239. In the past, none of this mattered because of the formula. That's no doubt why our clients never been required to register. But with the formula being different, everything suddenly becomes very important. And then paragraph 9, can you confirm that it's the Department of Business's view that our client has no construction establishment and you won't try and collect levy? In those circumstances, we're happy to accept that we don't have standing. That confirmation was not ultimately given, and Hudson Knott then brought a claim for judicial review of the 2015 levy order, which was ultimately unsuccessful. What the board then did was what Hudson Knott had feared, and that's in tab 37 of the supplemental bundle. And this is where my bundle split is, tab 37. I hope
It's the same for us, I think.
And then tab 37, there's a letter from Mr. Byrne of the board. Well, we've seen your letter, your correspondence with the government legal department. Well, we think we're going to register you at that point. So those are the circumstances in which the registration in fact occurred. And the registration was ultimately completed by the board on the 16th of February 2016.
So did Hudson reply to this letter and fill in the questionnaire?
What it did is it replied saying, this is tab 38, requesting that the CITB wait until the judicial review had been concluded.
Right.
And then the board say, no, they don't particularly want to wait. Hudson then, this is tabs 39 and 40, saying, we think you ought to wait. And then it culminates at tab 41. The board say, we'd like to give you the opportunity to fill out our forms. Hudson responds saying that your position up until now has always been that we're not registrable. And then tab 43, the board decide to register. And they decide to register on exactly the basis which I've identified, which is that following the decision in Beacon Roofing, a case to which the board was a party and which was all about Hudson, because Beacon Roofing was a case about Hudson's business model, which Hudson was correctly cited as the intermediary. They decided, oh well, now we are going to register in exactly the way that was feared. So the long answer which I've given to my Lady Justice Laing's short question is that the circumstances of the registration are such, we say, which support Nott's position, because Nott, from an early stage, as soon as a draft order was identified, was asking reasonable questions about what it needed to do to protect its position and asking for the assistance and guidance of the board. And it did not get much in the way of helpful assistance and guidance. It got a stonewalling response, and then ultimately it was registered, but registered too late, so that it had to wait for a waiting period before it could claim glance in the relevant year. Now, it may be said, well, tough, but that is, we say, a relevant circumstance when considering whether the judge was right, that it was necessary to consider a departure from the policy, and whether in all the circumstances the board did understand what it was doing, and ultimately whether or not Hudson was treated fairly.
Just for my note, when was the date of the unsuccessful JR?
The date of the unsuccessful JR was, I'm just coming to the permission hearing, but the final...
Oh, sorry.
I will give my lord that date now, if I may. Avoid forgetting it.
If we're coming to
18th of April 2016 was when Mr Justice Carl's judgment.
16. Thank you very much. Sorry, it was just for my
No,
note.
I'm very grateful, and that was a couple of months after the date of registration.
Yeah. Thank you.
Two more factual elements before I make some actual submissions on the case. First of all, there is the judicial review that we've just seen the culmination of in front of Mr Justice Kern. There was a permission hearing which took place in October 2015, and that is the basis of the legitimate expectation argument. Just so I deal with it in roughly chronological order, that's in the second supplemental bundle at tab 73. Page 351. This is an agreed note of the permission hearing. The document is not dated, but the hearing was on the 8th of October 2015. And the relevant part is at page 359. I should probably pick it up at page 358, I apologise. At the bottom of the page, we have the submissions made by counsel for Hudson Nott on ground 4, which is the rationality of the 2015 order. And the last substantive paragraph, there's a reference to Hudson's turnover and profits. It's said that it will be one of, if not the highest levy payer, and then will not be entitled to any grants for training. So facing a world where a liability of 12.5 million, which is greater than the profit it makes, and cannot pass the burden either up or down the chain, and then it's suggested that that's terribly unfair. And then over the page, first of all, it said we should have assumed the risk, but they assumed income tax risk, not levy risk. And then this, it said we'll get grants, but it's been made clear that Hudson will not be getting grants. And then counsel for the board, SG, that's Mr Krasinski for the board, can Mr Peacock make it clear from where he gets this? And then there's a reference to the terms and conditions of the grant scheme, section headed who cannot apply, and then it's read. Now, what was being read there was the 2014-2015 grant scheme. And we know that because it's the section headed who can't apply, which is a section heading which is present in the 2014-2015 scheme. And then Hudson's understanding, as this is repeated in the 2015 version, so he's not talking about the first one that we're talking about in this case, is that they'll not be entitled. Of course, it's in the same terms, but different wording and with a different section heading. So what counsel for Hudson is talking about there, and what he's reading to, is the temporal requirement. When Mr Krasinski for the board says, I can explain this is a misreading, and that they will be entitled. And then he does so in his submissions, which are on page 366.
Yep.
It's the 5th paragraph on page 366, just before the heading, question whether operates construction establishment. Mr Krasinski says in response, the reason I raise that is to direct to the mischaracterisation of what Hudson does, that somehow being outside the provision of workers, they will not benefit from the training. From the documents that have been shown to the court, there's nothing that prevents Hudson from benefiting from grants. And the judge ultimately rejected the application for permission on the proportionality grounds. Now, the purpose of those submissions made by the board was to seek to persuade the court that there was nothing in the proportionality ground, and that the supposed unfairness of being liable for levy, and that, but in reality not being able to obtain grant, was one which was illusory, and that the point which was being made and raised as a specific concern, temporal restriction, specifically cited to the court, was not one that anyone needed to worry about. And we say that amounted to a legitimate expectation.
Well, that's a little bit compressed, isn't it? What are you saying the clear and unambiguous representation was, just so I can get a note of it?
Yes, it would be that Hudson Knott would be entitled to make a claim for grant, and that any claim would not be barred by the specific provisions that have been referred to the court by its counsel.
Whenever they made it.
Well, yes, because
It's an open-ended promise. Didn't matter when they made it, no time point would be taken. All right?
well, that may be a separate issue, the question of whether or not a retrospective claim would
Because
be,
no claim had been made at this point.
no claim would be made at that point. Whether a retrospective claim would be permitted is another question. But at that point, Hudson made clear that it wished to claim grants if it was going to be subject to levy, but it was concerned it wouldn't be able to. And the board's response was no, no. That particular provision, and what was shown to the court, is the temporal restriction, we say, is not a bar. Now, there may be other grounds of non-eligibility, And that's not to say that the board would not be entitled to consider a claim for grant on the basis that, for example, you haven't produced enough evidence of X, Y, Z, or we don't accept that on the 15th of October this operative did this toolbox talk or whatever. That couldn't possibly be the scope of the legitimate expectation. But we say on that narrow issue, that creates a legitimate expectation, and the board would therefore have to have justification to resign from it. Now, it may have justification, and I'll come to that, but we say it creates one. Just to fill out, or just to show my Lord Justice Coulson the dates on which not Hudson indicated it was going to make a grant claim, that can be seen in the supplemental bundle of tab 49, second supplemental bundle. This is a letter to the Chief Executive of the Board from not Hudson. It's headed without prejudice, but it was written by my lay clients, and it's agreed between the parties. It's not, in fact, without prejudice in the legal sense.
Sorry, which tab again?
Tab 49 of the supplemental bundle, page 278.
I've got that. Yeah, thank you.
And
this is the protective grant claim.
this is the protective grant claim, and so it was intimated that such a grant claim would be made from at least this date, from at least the 16th of May 2017. And what was proposed was a meeting to agree what type of documentation and evidence the board was likely to require in order to make out the grant claim. Because at the time, it was Hudson Knott's understanding that it would be eligible in principle to claim grant if its challenge to the levy assessment was unsuccessful. And indeed, some of the evidence which was before the administrative court in this case, and I won't refer to Hudson Knott's evidence, but to the board's evidence, was that for a number of other levy payers, a number of other grant conditions have been waived in various circumstances, including requirements as to whether payments were up to date and permitting retrospective claims, and accepting alternative forms of evidence. I won't go through that evidence, the judge referred to some of it in her judgment, but it's in Mr Burns' witness statement for the board between paragraphs 214 and 229. Eventually, the board took its decision. The court's seen the decision. I'm not going to go through it, and we know what the board approved and what the board rejected. And then there is the final relevant fact, which is that the claimant ceased to be an employer in the construction industry on the 25th of March 2018. Again, for what it's worth, it's marked on the diagram. And the claimant, or not Hudson, ceased to be within the scope of the levy because it transferred its business to a new entity in Guernsey. And the parties are agreed that takes that conduct outside the scope of the levy. This brings me to the respondent's notice point, which is when the board knew about the corporate reorganisation. That corporate reorganisation was, as would be expected, fully set out and explained in Hudson Knott's accounts, and it was first explained in their accounts for the year-end 5th of April 2018, which were lodged at Companies House on the 21st of December 2018. And we know that the board and its solicitors read those accounts when they were lodged at Companies House, because when they were lodged, it immediately triggered off a round of inter-solicitor correspondence as to whether Hudson Knott was still a going concern in light of what had been reported in the accounts. And one sees some of that correspondence in the bundle. It's in the second supplemental bundle. If I could ask the court to look at tab 56 at page 293.
Before we look at this doubtless fascinating correspondence, did Knott ever say we're no longer employers in the construction industry?
Well, that's what their account.
Call me old-fashioned, but that might have been quite a simple way. There's an awful lot of stuff from KPMG. Is there anything that just says we're no longer a construction industry? We've transferred everything to Guernsey?
Well, at the time, everybody was litigating about the first levy year. This only concerns subsequent levy years, for which we think assessments have not been raised yet.
Is the answer to my question no?
No, there wasn't a letter on that date saying to the board, no, we have transferred our business. But there's no doubt that the board were well aware of it. And
It's not transferred business, it's we are no longer an employer in the construction industry. That simple statement, that wasn't made, as I understand.
No, there wasn't a letter sent in on the 25th of March 2018 saying we are no longer an employer in the construction industry.
Yeah.
But what that was done is it was reported that the reorganisation had taken place and that Knott Hudson was no longer in practice trading.
The reorganisation may have been occasioned for a range of reasons, but one presumably was to remove Hudson Knott from this difficult position they were in.
Oh yes, there's no
So,
doubt.
so why not write and say?
It wasn't a range of reasons. It was the
Yes,
reason.
that's well, I was being polite.
Yeah.
But why not write and say we're out of this now, as from this date?
Well, it's because at the time everyone was a bit busy litigating about the first levy year, which is a substantial amount. It was set out in the accounts. It was then, those accounts were immediately read by the board solicitors, and they started writing saying, well, how are we going to get paid our levy? You're not a going concern if we're no longer trading. You're still paying dividends. What's going on? And that's the correspondence at tabs 56 and 57. And that correspondence expressly refers to the 2018 accounts. So we say they must have been read.
So,
And as a result, we say the reorganisation came as no surprise to the board. So at tab 56,
sorry, it expressly refers to the 2018 accounts on page 293.
yes,
Right. Reference to the letter. Right, I see, yeah, got it. It's the main paragraph in the middle of the page.
and that there's I'm afraid that there is, sitting behind this, more correspondence about this, and it's clear from the board's correspondence as well that they had read the 2018 accounts because they cite the figures which are paid in respect of dividends in those accounts, and they complain about them, and they say, look, how are you going to pay our levy if you're not in business anymore? What's going on?
Thank you.
So turning then to submissions on the grounds, and with that groundwork I hope to be able to make them relatively briefly. my fourth topic is ground 1A, which is the temporal restriction. The judge held that the board did not consider whether or not to depart from the temporal restriction. That's paragraph 20 of the judgment, and I think that was common ground. The judge also held that the board acted unlawfully in failing to do so because there was at least an implied request that it should do so. And a failure to consider in those circumstances was unreasonable in the sense of being irrational. That's the cross appeal, and I'll deal with that at the end if I may. We say the judge should have gone further in three different ways. First of all, the judge need not have remitted this issue. Secondly, if we're wrong about that, and the judge was going to remit, the judge should have given further relief in order to accurately guide the board on reconsideration. In particular, a declaration that the board was in breach of its duty to produce an assessment of Hudson Knott's levy obligations. And then finally, this is the fifth point, which I'll develop, ground 1B, that Knott also should have won on the alternative basis of a legitimate expectation arising from the submissions made by its counsel in the judicial review.
Yeah.
So, in order to identify what we say is wrong with the judge's reasoning, could I ask the court to take up the judgment below, which is in the core bundle at tab 12. And we'll pick it up, if I may, at paragraph 21 of the judgment, which is on page 127 of the bundle.
Yes.
And paragraph 21 is the finding which is the subject of the board's appeal. And then at the end of paragraph 21, the judge explains that it's for the defendant to essentially reconsider this issue, having regard to all matters relevant to that decision, as counsel agree. And then paragraph 22 is the but. This is the bit we complain about, subject to one consideration, which is a matter for the court, namely the proper construction of the levy order. And the first thing the judge says is that, well, the claimant has conflated the basis on which the quantum of the levy imposed on an employer is assessed under Article 5 with a duty proactively to seek and register such an employer. And the judge's conclusion is that there is, in essence, no such proactive duty to seek out and register. And then the judge points out that the claimant had made persistent and trenchant representations that it wasn't an employer in the construction industry, and the judge concludes that Knott Hudson's position is fanciful and opportunistic, as she puts it. We say that that analysis is not correct under the statutory scheme. That the effect of Article 5.1 of the levy order is that the board is under a duty, a mandatory duty, to assess the amount of the levy to be paid in respect of each construction establishment of an employer. And in order to carry out that duty, it must be the case that there is a duty to seek to identify all construction establishments of employers. And the judge seemed to think that was just about the issue of quantum, which with respect we say it's not. We say the duty in Article 5 can't be fulfilled unless each employee in construction establishment is identified. There's then a further duty in Article 10 to serve an assessment notice, which may of course be nil. We say this is not a discretionary scheme when it comes to implementation, And it's certainly not proper, particularly when one considers the consequences for grant, to sit back and say, well, look, we're just not going to bother trying to register these people who are going to complain about it and sue us because they don't agree with us, when in any event it's going to be a nil assessment, which of course it would have been for many years, and everybody accepted that. And if the board decides that they're not going to, because it's just not worth it for them, it's then very difficult, we say, when they change the rules, to come and say, well, no, if only you'd been registered earlier, then you wouldn't have had to wait, but you weren't, and so tough. And with respect to the learned judge, we don't accept that anything about Hudson Knott's conduct has been either cynical, fanciful, or opportunistic. All it's done is to pursue its right to challenge liability to the levy, and also, in these proceedings, the issue of grant. And it is notable that in respect of liability to the levy, those issues are issues which have attracted the attention of this court on at least one occasion, and permission has been given for those claims. Now, they've ultimately been unsuccessful, and no complaint is made about that. Knott and Hudson have lost some points of law fair and square. But to suggest they were not properly arguable and serious points, for which courts, including this court, have given permission, including for second appeals, is, we say, wrong.
But the money hasn't been paid.
No, the money hasn't been paid. And that's
So it was all, in that sense, regrettably a waste of time.
well,
'Cause this is all about the recovery of money.
yes, it is about money. Knott and Hudson wish to minimise their legal liability, and the board seeks to maximise.
Including, in this instance, not honouring a judgment of the court.
Well, the order of the court can't be complied with at the moment because the company doesn't have sufficient money, and no enforcement steps have been taken by the board at present. There's been no breach of any court order requiring payment, and there's been no attempt to wind up the company or to place...
I mean, this is the underlying judgment that was the subject of the unsuccessful appeal,
Yes,
which is outstanding.
yes, there is an unsatisfied levy assessment.
Yeah.
Correct. And the company is not in a position to pay that assessment. And whether or not the company is able to survive will depend on the amount, if any, of grant, which it secures as a result of these proceedings and the board's assessment. And there have also been statements made by the board that if there isn't ultimately enough money in the company, they're going to go after the directors, which is, of course, their right if they wish to do so. But the effect of this judgment, which is an unexpected liability, which the board is pursuing and which says can't be set off for grant, is existential for this company. The business is being run by the same people offshore successfully and still paying very large amounts of tax to the Treasury. But nonetheless, the effect of these proceedings is existential for this company. That's the position. We say there was an obligation on the board to register and to carry out an assessment. And registration is merely an administrative step, which means putting someone on your list for an assessment. And the board had been well aware of Hudson's business model and the reasons why maybe it should have been registered since at least 2011, when Beacon Roofing was decided. And the fact that on principal grounds, which ultimately have failed, Hudson disagreed at the time that it was an employer in the construction industry is nothing to the point. That's why the board have powers to produce their own assessment if someone doesn't cooperate or doesn't agree with the assessment process. It doesn't remove their obligation. So we say in paragraph 22, the learned judge was right to say that her conclusion about remittal was subject to one consideration, which is her reading of the levy order. But we say, with respect, her conclusions as to the meaning and effect of the order were incorrect. And that on the question of remittal, there was, we say, one correct answer, which is that there ought to have been waiver of the eligibility condition of a waiting period. And even if that's wrong, there ought to be declaratory relief setting out the correct meaning of the 2015 order, because on any view, if there is an obligation, as we say, to produce an assessment, something the judge disagreed with, that would have been will be a highly material consideration on remittal. The board, in support of the judge's analysis, in addition to it, make an additional point in my learned friend's skeleton argument. And they say, well, it's very difficult for them to get information. And we say that's a concern which is incorrect, because Section 6 of the Industrial Training Act permits the obtaining of information from employers in the industry. And so if they want to obtain information, they can obtain it. And secondly, there's no doubt that they were aware of Hudson Knott's activities and were able to register and assess them if they wished to. And indeed, the amounts involved, the quantum of the assessment, has never been in dispute. It's a very simple number, 1.25% of the net CIS payments, which of course are reported to the revenue electronically on a daily basis. Not a number in dispute. So, as a minimum, we invite the court to correct what we say is an error in paragraph 22 and declare that the board did breach the 2015 order in failing to assess, because we say either that's the sole correct answer, or at the very least, it's a highly material consideration on the matter. That's ground 1A.
Thank you.
Ground 1B, in my fifth topic, is legitimate expectation. That's dealt with in the learned judge's judgment at paragraph 24. I should say, on the law relating to legitimate expectation, I hope I'll be forgiven given the time of not ploughing through Re Finucane and MFK underwriting and so on. I think the principles are set out and more or less agreed in the skeleton arguments.
Yes.
And there needs to be a clear and unambiguous representation, and such a representation can be resolved from where it's in the public interest.
Yes, I saw Mr. Knight nodding before you gave that summary. He's
Yeah.
still nodding now. So
And that was the analysis adopted by the judge. Where we say that the learned judge, with respect, went wrong is in paragraph 24, where she says this aspect of ground 1 falls at the first hurdle. Nothing in the note of counsel's submissions indicates a representation of the requisite character. At first, it refers to a heading which doesn't in fact appear in the policy, and must therefore have been inaccurately identified by counsel or noted by the solicitor.
the heading, was it, who can't apply? Was that wording
Yes.
in the note?
And just to go back to see what we say the judge's error was, at tab, in the supplemental bundle, at tab 14, we have what counsel for Hudson Knott was reading from.
14.
14.
1-4, yes, my lord, 14 of the supplemental bundle.
Tab 14 is
Tab
the...
14.
Tab 14, page 140, yes.
We've been here before,
yes,
but
yes,
you're
yes.
taking
Sorry,
us back.
yes.
I'm just taking back to it because
yes. Who can't apply?
who can't apply?
Yeah.
And that's the section heading, which counsel has then recorded as having read out. And that's the section heading which is about the temporal restriction, the waiting period. And then counsel said, and the 2015 policy, which is tab 15, is to the same effect, although the headings are slightly different. So the submission which I made to the learned judge is that the submissions that were being made to the court about ineligibility for grant were all about, look at this temporal restriction. Now, what the judge said is, well, no, there must be some mistake, because who can't claim refers to a heading that doesn't in fact appear in the policy. And
Can you just take us back? I'm so sorry, Mr. Jaffe. Take us back to the note of the hearing.
yes, of course, the note of the hearing is at tab 7,
It's tab 73.
tab 73.
Yeah, and it's, if it's easy, it's quoted in the judgment at page 110.
And the relevant part is page 359. So at page 359 of the supplemental bundle, Mr. Grzyński says, can Mr. Peacock, not Hudson, make clear from where he gets this? Tab 29, the terms and conditions of the grant scheme, the section headed who cannot apply, and then it's read out. And then one looks at the 2014 terms and conditions, and there is indeed such a heading. It's the third heading, who can't apply. And then we've seen what's underneath it, which is the temporal restriction. And then we turn over to tab 15. We've got the 2015 terms and conditions. There is no heading, who can't apply or who cannot apply. What we instead have is a heading, who can't claim, and what criteria must be met. But counsel for Hudson Not referred to both of the policies, and because he then went on to say Hudson's understanding, as this is repeated in the 2015 version, is that they'll not be entitled. They will not be entitled.
Right.
So what the judge does is to say there must be some error. Because the reference to who can't claim doesn't in fact appear in the policy, and therefore it must have been inaccurately identified by counsel or noted by the solicitor. But the judge has misunderstood which version is being referred to. The version that was being referred to in counsel submissions was initially the 2014 version, which does indeed have that section heading. And then he goes on to say, and when you look at the 2015 version, the substance is the same.
Right.
So we say that the judge has rejected this argument on an incorrect factual basis.
Yes, just so that I've got it. The judge has got just the wrong text from that she's quoted, correctly quoted what's said in the 2015 document under who can't claim, which is in relation to businesses which are classed as in scope and employers whose main activity is not construction. But the point was not that; it was the in 2014 who can't apply. First bullet, newly registered employers, is the temporal clause, which is repeated in 2015, not under the heading who can't claim, but who can claim.
Yes.
Have I misunderstood?
That's the submission.
That's it, and the judge has simply gone to the wrong text.
Yes.
Yeah.
And that's the basis on which this argument failed in front of the learned judge.
So none of her sort of full further reasoning. So you say all her further reasoning, even though she says secondly, that's all contaminated by the error that she makes about the document.
Yes, because all of the reasoning from secondly is predicated on there not having been a clear and unambiguous representation about the topic that we say was being discussed, which is the temporal restriction. It would be very difficult, we say, for the judge to come to the second part of the reasoning if the judge had, we say, accurately understood what was being spoken about in that part of the submissions, and ultimately being responded to by the board's counsel. because of the specificity of the submissions that were being made and the topic about which they were being made, an exclusionary rule that Hudson Knott was concerned would apply to it. We also say that no good reason has been advanced by the board for resiling from this assurance. And we say particularly so, given that before the decision under challenge in this case was made, the requirement of a waiting period was removed from the board's general terms and conditions. It had ceased by the time of this decision to be the board's general policy and was not considered necessary.
And the fact that the judge, you say, made the mistake that you have described and I've clarified, arises, doesn't it, because the note of the exchange between counsel, whilst it's possible for us to be taken to the documents and read it, it's not itself explicit that it's referring to the temporal restriction.
No, but those
It's
are the
just
submissions.
we can't claim. It's been clear that the claimant will not get grants. And so the overall topic, will the claimant get grants, is a much bigger one than they won't be able to get some in the first year.
No, but the bit that was being read out by counsel was the temporal restriction.
But I can see that there's potential ambiguity.
If it's being said that's insufficiently clear and unambiguous, we say that's perfectly enough, because counsel's saying, look, we're just not going to get grants under these terms and conditions. And this new scheme is going to be brought in for the calculation of levy, but we're not going to be able to get a compensating grant payment, unlike everyone else, and we're going to be in a very bad position. And that's why this order is irrational. And look at this, and the relevant bit is then read out that says there's just a bar, it's a waiting period. And that's the submission that's being made. Now, in response to the board's submissions, the judge decided that the rationality ground was unarguable, because the board was saying, don't worry, you'll get your grants. And we say in the circumstances, that creates a legitimate expectation which the board have to put forward good arguments as to why it ought to be able to resile from. We respectfully say it hasn't. And there are many features of this case that are very, very unusual, and it is essentially unique because the issues in this case are transitional. They arise as a result of the board changing from one levy formula to another, taking lots of firms outside the scope of levy, bringing other firms in, including this one, and this one had imposed on it the largest annual levy payment we understand that's ever been imposed on any construction company. And uniquely, there will be no compensating grant payment. And it's unclear whether or not that was ever the intention of the board. But we say whether or not it was the intention of the board, the manner in which it was done was unfair in public law terms. And the judge has agreed up to a point, a limited point, and we say it goes a bit further than that. Again, subject to any questions from the court, I will move on to my sixth point, which is ground 2 and the tripartite requirement.
Yep.
I'll deal with ground 2A first of all. Ground 2A is that there was no tripartite requirement that could be imposed on Knott in the first 2 years. That's because it was removed from the policy deliberately and it can't be read back in or applied. The judge agreed to the limited extent that you couldn't read it back in, but the judge concluded that in October 2017 a letter was written to Knott saying that the tripartite requirement would be applied, and that was enough to make it lawful to apply the requirement when the decision was taken in 2020. That's the shape of the argument. The starting point of this argument is the board's decision, which is in the core bundle at tab 22. The relevant part is paragraph 2.1 on page 269. You, that's not, dispute that the grant terms and conditions require that Hudson identifies the need for training, organises the training and accepts the cost of training in order to claim grant. As explained in the board's lawyer's letter of the 26th of October 2017, express reference to these factors was made in the terms and conditions for 2014 and 2017, and the only reason they didn't appear in 15 and 16 was an administrative oversight rather than because of any change of policy. Well, first of all, as the judge found, that is an incorrect statement. And that is clear, we say, from paragraph 27 of the judgment below, which is core bundle, page 130. The judge concluded at paragraph 27, having regard to the selective nature of the text which had been removed from the predecessor policies, I accept Mrs Jaffe's submission that it's inherently unlikely that it had been removed by way of oversight, and that in any event the tripartite requirement was not one which an objective reader could discern from the relevant policies themselves. And indeed, that conclusion of the judge was supported by the very fair and candid evidence of Mr Byrne for the board, that was obviously produced after the decision in the context of the judicial review, saying that the tripartite requirement may have been removed by an officer deliberately and in good faith. And they didn't know because the person had subsequently left. All Mr Byrne was able to say is it wasn't approved by the usual procedures and at board level, and he would have expected to find some explanation, and he hadn't. We note that at the same time as this requirement was removed, the leaflet was published explaining that there was an aim of simplification of the rules, and that certain other requirements were also deleted, including a requirement for a written confirmation from each claimant, confirming that there had been no double claiming in respect of training provided by subcontractors. So the judge, we say, was right that a reasonable reader of the terms and conditions would come to the conclusion that the tripartite requirements were not requirements and that they had been removed deliberately. And the reason for the decision below ultimately comes down to the letter of the 26th of October 2017. And had it not been for that letter, I don't want to infer too much, but it may well have been that the judge had rather more sympathy with Nott's position.
Is that paragraph 30?
Exactly, that's paragraph 30. If I can attempt a summary of paragraph 30, what the judge says, accepting the submissions made by my learned friend Mr Knight, is that it may not have been the policy originally, but Nott was put on notice of, on any view, the reintroduction of that policy, and that its claim for grant would be judged by reference to the reintroduction of that policy, and so it's got nothing really to complain about.
But it's a policy that presumably goes to the very core of the whole scheme, that you're giving a grant only to someone who's identified a training need, organised the training, provided it, and paid for it. That's what you're getting the grant for.
Yeah.
Isn't it obvious that that would be, even if it's not stated, at the core of what's going on?
Well, not necessarily. One may pay grant when, for example, the levy is imposed on one person in the chain of contractors. The training is carried out by another.
I see.
But that other person can't claim for the grant.
Right.
And if that person lower down the chain, the subcontractor, is contracting through a company like Not Hudson, and the cost of the training is the cost of paying the person who receives the training whilst they're doing it, then it does make sense to say that the grant is applied to those costs. Because the aim of the scheme, combining levy and grant, is to incentivise and encourage and reward those companies which train their own employees and their own subcontractors and their own self-employed contractors, and to impose levy which can't be recovered on others.
Yeah.
And
Thank you.
where we say in practice that's occurring, there is good reason for doing that. We also say, and this is ground 2B, we do comply with the requirement, but I'll come to that. So that brings us to the letter of the 26th of October 2017. That's in supplemental volume 2 at tab 52. Page 284. And this is a letter that requires, we say, to be read with a degree of care. It's a solicitor's letter from solicitor to solicitor, and it sets out the board's position. What one might expect it to say is we are changing our position in the public interest to reimpose this requirement, and we are imposing it on you. That is not what we say the letter in fact says. What the letter in fact says is that as a matter of interpretation of our published policy, we say it's still there and it was always there, which is the argument the judge, we say, rejected, and rightly so. So the letter is headed retrospective grant application. Then the second paragraph, the board concludes that the claim is going to be rejected, and we set out below the reasons for this decision. Then under the heading Hudson, it's recorded that Hudson was registered. Then the grant scheme terms and conditions are quoted. And then at page 285, there's the important bit. At the top of the page, there's a heading Requirements. And the third line after Requirements is the grant scheme terms and conditions for 2015 and 2016 did not make this, that's the tripartite requirement, explicitly clear. This provision was removed due to an administrative error, well we now know it wasn't, and did not represent a formal change of policy. The provision has formally been reinserted into 2017-2018, that's correct, and you can find that online. Nevertheless, the requirement to identify the need for training, organise training and accept the cost of training remained during the 2015 and 2016 grant years, terms and conditions, and continued to be applied in practice in assessing applications for a grant. This is implicit from the terms and conditions in those years. And then the letter goes on to refer to a meeting which took place, and then the last line of the letter on page 286, the board rejects the retrospective grant application. Over in the next tab, at tab 53, there's the response to this letter from Not solicitors at the time. And they make perhaps the obvious point at paragraph 1 hang on, we haven't submitted our retrospective grant claim yet. We've just said we're going to, and we've had a meeting with you about how it should be prepared and what evidence you want. And then paragraph 2, under the heading Relevant Terms and Conditions, it's then said at paragraph 2.2 that your argument doesn't work. It stretches basic principles of interpretation to suggest it's implicit in the passages you cite that there is such a policy. And then the obvious interpretation of the removal of an express requirement from the terms and conditions is that it no longer applies, and compelling evidence will be required to the contrary. Then the end of this chain of correspondence is tab 55. The board somewhat relents on the 12th of September 2018. The first paragraph, you indicate you intend to submit a grant application. If you consider you're entitled to make a claim for grant, you should submit a claim as soon as practicable, and in any event no later than the 30th of November 2018. And then the arguments are responded to, Hudson Staples retrospective grant. And then on page 292 at the top, there is a confirmation that no decision has yet been made. Even so, CITB will consider any grant claim submitted by Hudson on its merits. So, again, with respect to the judge, we say that the October 2017 letter does not bear the weight which the judge seeks to place on it. It's not a statement that a policy is being changed in the public interest. What it is it's a lawyer's letter saying that you can read these requirements into the policy implicitly, which we say is a thoroughly bad point, and the judge agreed with a bad point. The letter also says it was just an administrative error, something which the later evidence in the judicial review showed to be incorrect. And they said you can imply it in, which you can't sensibly, we say. And then when these points are made to the board relents and then says, all right, we'll put in your application and we'll consider it on its merits. What it is, this letter, is it's just an advanced statement from the lawyers about the arguments which the board is minded to run in its final decision. And we say it's an advanced warning that the board was intending to do something which was unlawful. So that's what we say about ground 2A. And the legal basis on which we pursue that, we put in more than one way. It can be put, for example, as an argument of legitimate expectation, that having published a policy in specific terms, you can't resile from it without a good reason in the public interest, and we say no good reason has been advanced, and the reasons that were advanced are unsatisfactory. Or you can put it as a lumber-style secret policy. In other words, that you've announced that you're not applying the tripartite requirement, but in fact you are, and that is unlawful again, without a good reason. It amounts to the same thing, not least because these doctrines have very similar jurisprudential sources. But the reason the argument was rejected was really based on the letter from October 2017, which we say is not a satisfactory basis.
Now, it may not be necessary to show that somebody's relied on a representation. Do you suggest that your clients did rely on this in some way to their detriment or not?
What we say we relied on to our detriment is the correspondence which took place earlier in 2015, which I showed the court about asking how not Hudson would be introduced, is the language that would be used, to the board, and the availability of grant claims. So we do accept that this is detrimental reliance is not a requirement, and that we don't have a detrimental reliance argument in the traditional way of you made us this promise and we changed our position in the following way in reliance on it. But we do say that there is a course of conduct under which we raised our concerns about what was going to happen at a reasonable time, but not made clear what its concerns were, and that it wanted to have open and frank discussions with the board about how to mitigate them, especially in relation to grants. And its worst fears were realised as a result of the board's conduct in both registering it and then imposing its rules in a way which were both not written down at the time, or imposing rules which were unfair in all the circumstances to apply to it. But I do accept in response to my lady's question, this is not an absolutely kind of classic detrimental reliance situation.
Thank you.
That brings me, if I may, to ground 2B, which is the substance of the tripartite test. And that's relevant in the final of 3 years, 2017, 2018, because the requirement was reintroduced during that period. And it also arises in the event that my submissions are wrong in respect to the first 2 years. And the judge, as we know, concluded that the test was not met in any respect. We say that where the judge went wrong was in her construction and interpretation of the test, because obviously its application is a matter for the board.
Sorry, in her construction
Construction of the test, and interpretation of the test.
of the test.
Of the tripartite requirement as it appears in the rules.
Oh, I see.
Yes.
Okay. Yeah.
Because the application of the test, as a matter of obvious public law, must be a matter for the board, and not for either not or the court.
So that explains why, because I wondered about that. In your skeleton, you talk about construction of the policy.
Yes.
And that's what you mean.
Yes.
The construction of the arrange, pay for, whatever the words are.
Right, I'm sorry that wasn't.
No. I because I was thinking, well, is this a matter of fact? And I couldn't quite work it out, but you've explained that to me. So it's the construction of those words.
Yes.
Yeah.
So, just to step back a moment and understand the context. Prior to the third levy period, there was lots of training taking place every day. In practice, all of Hudson's clients were registered with the board, and in practice, most of them would be doing training and claiming grant for it, because they were subject to levy. And of course the board knew that. It was reviewing their grant claims and happily paying them or setting them off against the levy obligations. So there is a sense in the board skeleton before this court that it really has no idea whether any training was going on, and we say that's quite unrealistic. And it knows exactly what training is in fact going on by Knott's clients, and it has the best records of them. Now, come the third levy period, the levy obligation moves to the claimant. And many of Knott's clients cease to be eligible for grant. Now, just to make that good, that's clear from, let's look at the 2015 policy at tab 15 of the supplemental bundle. Page 147, there's a heading, who can't claim, which is the second heading. And the heading is businesses which are classed as in scope excluded. They may have no direct employees. And that's the position that many of Knott's clients became in, because their practice, let's say you have a small roofing firm. What it does is it goes out and competes for subcontracts on a larger construction project, and it has a team of self-employed individual contractors that it routinely uses. Those individual operatives are contracted through Hudson, but often that company will have no employees in the construction industry of itself, and so it may not, following this change, be able to claim grant. And that's the classic Hudson Knott model. Very small subcontractors with a relatively small number of individual operatives who are competing for larger subcontracts. But the training, of course, is unlikely to have stopped. To the contrary, Knott's clients are likely to have continued to provide on-the-job training as they always did, but on the board's analysis, it can't be claimed for. And we say that's an unlikely outcome. The way in which we say that the tripartite requirements are met is through the terms and conditions, which Hudson has with its clients, and the separate terms and conditions with operatives. Those terms and conditions are in the second supplemental bundle at tab 71. This is the standard form terms of business used at the time. At the bottom of page 334 there's an explanation of the basic business model, which I don't think we need to go through. And the relevant provisions of the terms and conditions are at page 335, clause 6 at the bottom of the page. The client accepts all responsibilities under all applicable health and safety legislation in respect of the freelance operatives engagement. So that's the contract between Hudson and its client. And then tab 74 is the standard form with the operative. At page 371, in the right-hand column at clause 7, Roman 5, comply with the requirements stated in the client's health and safety policy.
Sorry, you have to give me that reference again.
It's a tab 74.
Yeah, page 371.
371, the right-hand column, Roman 5 towards the top of the page. Comply with the requirements in the client's health and safety policy, and then Roman 6 to take all reasonable steps to safeguard his own safety and the safety of other individuals with whom he works. So, and I emphasise that the claim which is made for training provided by the clients is centred on health and safety issues, precisely because of these arrangements. So, how does Knott identify the need for training? Well, it identifies in both sets of contracts that there will be health and safety obligations which are owed on a construction site, which are generally met through a number of means, and in particular training. So there is an obligation on the client to safeguard health and safety, which will include, we say, providing appropriate training. And then there is a correlative obligation on the operative to comply with those health and safety arrangements. In other words, to attend the training, to participate in it. How is the training organised? Well, it is organised by imposing those two matching obligations on the client and on the operative to comply with applicable health and safety obligations, which includes running appropriate training. In effect, what's going on is that Knott is contractually, and it's unsurprising it's doing it contractually, delegating to the client and the operative the provision of necessary health and safety training and participation in it, respectively. It would be very silly for Knott to seek to run the training itself, because it's Knott's clients who are selecting the appropriate operatives, and they know what levels of qualifications and training they have and what training is necessary for their particular trade.
So these obligations are imposed despite the absence of the word training.
Yes.
From any of the relevant provisions.
Yes.
All right.
But I do accept that training in the most general sense, for example, IT training, is unlikely to be covered by these contractual provisions. Well, that's because there isn't any contractual obligation that it's done already. We also say it's important to note there's no requirement that not organise the training itself. Perfectly open to a firm for training to be carried out by a delegated training provider.
In both of the references to health and safety that you've taken us to, the implication of your submission is that the requirements either in the policy of the client or the overarching health and safety requirements include a requirement for training. And I don't think we've obviously been taken to that, but that's quite a leap, isn't it, to say that those phrases, compliance with health and safety policy or requirements, of themselves mean that the training has to be provided.
Well, we say it's not much of a leap, because that is how, in practical terms in the construction industry, health and safety is assured, by having regular ongoing training. That's how, if for example there's a negligence claim or a claim under the regulations which deal with health and safety, a company will be able to establish a defence, which is that something bad may have happened.
But we provided the training.
We provided regular initial training and ongoing training to the proper standards to ensure that people knew what they should have been doing, and accidents will happen. And so the reality is that that is how health and safety obligations are achieved in practice. The final element is to accept the costs of the training. The judge said that NOT doesn't do so, but NOT pays its operatives for each hour or day that they're engaged in training. So it is covering and paying for the costs of the training. It then, of course, recovers that cost from its client, as long as its client doesn't go insolvent or Phoenix or anything else. But then so does every other construction company that provides on-the-job training. So if you take a very traditional construction contract on a cost-plus basis, so in other words, we will do this job for the cost of our materials, the cost of our staff, plus X% markup, the contractor will be passing on in exactly the same way as Not Hudson does the ultimate cost of paying the staff, including the cost of attending training. But one would not say that this requirement was not met, that the contractor was not accepting the cost of the training. Of course, the cost is being recovered up the contracting chain, but that's exactly how one would expect it to be. So we say on a proper interpretation of the requirements, they were met by NOT's arrangements. And the potential criticism which my Lord the President properly puts to me, we say comes down to an absence of sufficient boilerplate in the contract. That there could have been an extra 2 or 3 pages saying, we expect you, at the risk of stating the obvious, to make sure that everybody is properly trained. We expect you to carry out your obligations to ensure that there is regular initial and ongoing training for your staff. And we will also expect the operatives to participate fully in that training and to comply with it and to make themselves available. But we say that's no different to the effective arrangements that were already in place. The final 2 points, which I hope deal with in a couple of minutes before...
Yes, entirely up to you. If you can, then do. But
I'll have a go. On the respondent's notice point on relief, I've already identified what we say are the relevant facts. We say that the board did know about the restructuring for all the reasons I've sought to identify.
yeah.
Then on the cross appeal, and I may return to this in a little more detail in reply, subject to the submissions that we hear, we say the judge was quite right to find this was a classic case in which the board should have considered, at the very least, whether to depart from its policy on the waiting period. The board accepts, very properly, that it didn't even consider whether to depart from its policy, even though the policy had been abandoned for the purposes of its general operations by the point at which it made its decision. we say in circumstances where not was being subjected to a disadvantage as a result of a breach of statutory duty, failure to assess and register. And we say it is ambitious for the board to say it did not even have to turn its mind to this issue at all and even consider the question. Now the board's answer to that is you didn't ask us to depart from the policy, so we didn't consider whether to depart from the policy. We say this is the point at which all the grounds start to link up, because this is a concern which Knox has been raising for a number of years, that it was well understood that it would require a number of waivers from the ordinary grant terms and conditions in order to be able to succeed, including the basic requirement that you've paid your levy and that you apply by the closing date, all of which were waived. And we say the board well understood it would need to consider the application with a degree of flexibility.
Is that the highest it gets? I mean, because conventionally, when a decision maker has a published policy and is criticised for not departing from it, the person concerned will have said or written to the decision maker and said, here's your policy, I don't meet paragraph 3 of this policy, but mine is an exceptional case for these reasons, please depart from paragraph 3. Now there's nothing like this in the bundle, so what's the closest one gets in any of the documents to a specific request of that kind?
Could I ask my lady to look in the core volume at tab
Yep.
17, which is the grant application. Given the back reference already. Tab 23, I apologise.
Sorry, Mark, I'm looking at the wrong thing too.
Yeah, that's right.
So the application consists of quite a lengthy letter.
Yeah.
The letter of the 13th of February 2020, which sets out the basis of the history of the claim and the eligibility criteria.
Yeah.
Then there is detail as to what is being claimed, and then the conclusion of the letter, page 278. We look forward to engaging with you constructively on these grant applications in a timely fashion. We continue to engage Martin Price, who's available to work with you on this, as he's done previously, and we look for a similar degree of cooperation and flexibility to that shown to Berkeley, which is another large construction company, and others being shown to Hudson, and to reaching a satisfactory conclusion for both Hudson and the CITB. So the way in which retrospective grant applications had been dealt with in the past was that most large companies who wished to make retrospective claims had engaged a consultant, and that consultant, who was usually but not always Mr Price, who's a former director of the CITB, engaged in discussions and negotiations about which specific terms were going to be applied and how they were going to be proven, how claims were going to be proven and so on. And flexibility as appropriate was being sought. Now, that isn't what happened here. What happened is the board came out with its decision, and then there is criticism that we haven't expressly asked for a departure from the policy. But what we have said is we are looking for a similar degree of cooperation and flexibility, and that's flexibility in the application of the policy, as has been shown to other companies, and we wish to engage in discussion and debate about that. And that led to the response.
All right.
What the judge said is that there was no express request, but such a request was implicit, that on the authorities, which I won't go through now, but which I'm sure Mr Knight will take you to, an implicit request is perfectly sufficient, so long as a failure to consider such an implicit request is not rational or reasonable. And that was indeed the express finding which the judge made, because on the particular facts of this case, we say the judge rightly found that failing to consider a departure from this critical aspect of the policy, indeed one that had been raised by counsel in submissions, wasn't reasonable.
Right.
my lords, my lady, that's the shape of the argument on that point, and I will return to it briefly, probably in reply, if I may, by reference to the...
Yeah, well, that's clearly the sensible course. Wait and see what's said, and then you can
But
reply.
unless I can...
No, well,
assist the court further
you've
on
been
the main
extremely efficient and clear. If over the lunch and adjournment there are other matters you wish you had said, please feel free to get back to your feet. Otherwise, we'll start at 2 o'clock, Mr. Knight, with your response to it all. 2 o'clock.
The court will be locked if you want to keep your bits in.
Thank you very much.